Good morning, everybody. Thank you all for joining us today. I'm going to start while we've got the last few stragglers making it in from the waiting room by going over our Zoom housekeeping tips like we do each week. The first thing that we do ask you to do is to stay muted during the Zoom Q&A unless you want to unmute yourself to ask a question, which of course you're welcome to do. Your Zoom toolbar is probably at the bottom of your screen, depending on what kind of device you're using, and that's where you will find your mute and unmute button, as well as your start and stop video button. That's also where you'll find the chat button, and that might be flashing right now because I just put a message into the chat. The chat is the best way for you to submit questions during the Q&A today. And I'll let you know right off the bat that we have a shorter list of questions that were submitted in advance this week. So we're more likely to be able to get to questions in the chat today than we are some weeks. And so if you've got something that you've been wanting to ask about, today would be a good day to put that into the chat. If you guys overwhelm us with your list of amazing questions and we don't get to them all today, or if you think of something during the week that you would like us to cover next week, you can email those questions to info@condolaw.net. And we do ask you to get those to us by Monday at 4 p.m. because that gives us a day to research when we need to and prepare our answers to the questions. All of that information is in the message that I just put into the chat. The other thing that's in the message I put into the chat is a link to our YouTube channel, which is where you can go to watch all of the videos of every Q&A we've done since we started doing these almost 4 years ago now. That's crazy. I can't believe it's been almost 4 years. We started these, I think, in April of 2020. So there's a lot of content on there, and you can search within our YouTube channel. So that is one way that you can look at our videos and try to search for content based on subject matter. The only thing is you're going to get a lot of results if you search something a little bit general like assessments, and you might get fewer results if you search something a little more specific like ratification, for example. I just put the YouTube link back in the chat because somebody asked me to enter the link again. That was the only link that I had posted in the chat so far today. I do have more links for you though, but I'm going to wait on that for one more minute, which is because I need to remind you that we are here to discuss general legal information, not give specific legal advice. And you're going to hear us say that a couple more times today when we get to a couple of the questions that are pretty specific. And I just need to remind you, as we do all the time, that you cannot get legal advice in a forum like this. In order to get legal advice, you need to establish a relationship with an HOA attorney if you don't already have one. They are the only ones that are able to give you legal advice because they are familiar not just with whatever particular question you have, but also your governing documents, whatever statute your community is governed by, etc. So keep that in mind, both as we're talking today and as you send us your questions via email for future Q&As. If you find yourself getting really specific or copying and pasting sections of your governing documents or writing many paragraphs of information, the question that you're asking is probably too specific for the Q&A. So on to the links that I mentioned I was going to put into the chat. I have two for you. Both of these have been in the chat the last couple of weeks that we've been doing the Q&A. The first one is a link directly to the proposed bill that the legislature is considering this session, which would eventually make all communities subject to WUCIOA, and which would also eliminate what they're calling the legacy statutes, the HOA Act, the Old Condo Act, and the New Condo Act. So that's the link that I just put into the chat. And the next one that I'm putting into the chat is a link to a sign-up website for the Legislative Action Committee Monday Morning Minute emails. So if you signed up for these last year, you have to sign up for it again this year, otherwise you will not get them. Our Legislative Action Committee works really hard during the legislative session. We work throughout the year, but especially hard during the legislative session. We meet at least once a week and have lots of emails flying around in between. One of our attorneys, Teresa Torgerson, who's actually not on the LAC, but has been very, very involved in the past, testified in front of the committee on the proposed, we're calling it WUCIOA for All bill. And the Monday morning minute emails are written by the Legislative Action Committee to keep you informed on what's happening from week to week during the legislative session. The session started on January 8th and runs until early March. And these emails are also going to be where, if there's a call to action where we really need folks to sign in and testify about a certain piece of legislation, that's where you're going to get that information. So if you want to stay informed about what's happening during the legislative session, sign up for those Monday morning minute emails. And Katie, unless you have anything else that we should talk about, I'm going to jump into our first question.
Sounds good.
All right, here it is. Can the board request the tally sheet or copy of the ballots received before the annual meeting? If not, what if the community manager shared the ballots to the board without knowing what are the consequences of this action? So the first time I read this question, I didn't realize the question was, can we see them before the actual meeting when the voting is going to be completed or continue taking place? And what my knee-jerk reaction was, of course, the board can see the ballots. They're a record of the association. The board is the group that acts on behalf of the association. And with extremely limited and rare exceptions, the board is entitled to review or access all association records. Upon a second reading of the question, a little bit slower, I realized that the question seems to be, when you are accepting ballots by mail, and your meeting hasn't happened yet, but some of the ballots have arrived, does the board get to see how the voting is going before the meeting occurs? So I think that's what the question is asking. If you're here, the person who submitted this question, and this is not a correct interpretation of the question, maybe you could provide a little bit more clarification in the chat. But I'm going to answer the question that I think is being asked, which is, can the board see how the voting's going before the annual meeting has actually taken place? And I think the short answer to this question is that it depends on what's being voted on and how exactly your voting process is going to happen. So is the voting taking place by mail, or will there also be in-person voting at the meeting? It might also depend on how close the voting totals are. It also might depend on what you're voting on. So disclosing votes for a declaration amendment in advance probably has little to no impact. Where if you're voting on, electing board members, for example, and current board members, for example, who might be running for re-election, are privy to information that non-board member candidates are not privy to, that could seem unfair. It could end up, I think, after the fact, even invalidating an election if somebody were to challenge the process in part based on that. So I think it depends on those factors. And if there is something where there's, self-interest on the part of a board because they're a board member, because they're running for re-election, I would say in general, the better thing would be to keep the votes confidential until the voting is complete. Now, part of the question seems to ask, what if we sent them the votes ahead of time anyways? How do we fix it? Or what are the repercussions of that? And I would say that generally in the event of an unintended disclosure, we would recommend that you consult with your association attorney, give them the specific information about how the voting is going to happen, what the issue that's being voted on is, what was disclosed to the board members ahead of the annual meeting, etc. And work with your association attorney to formulate a plan to ensure that the fairness of the election process is preserved. The easiest, simplest solution, if there's an unintended disclosure and you think it has impacted the fairness of the election, would be for the board to conduct a new election, call another meeting and do the election over again, and make sure that the voting process is confidential and fair so that you eliminate any of those factors that could have been present for the election in which there was this unintended disclosure. If absentee ballots are being used, we would generally recommend they not be disclosed to the board until the annual meeting or when the votes are being tallied, all the votes are being tallied. So until then, the secretary or election committee, if you have one, should keep the information confidential. If the secretary is one of the people running for re-election, maybe then you entrust that to your manager, right? So I think that I did get some clarification in the chat from the person who submitted this question, which is, can the board see the ballots ahead of time when it is a board election? And so I think I've answered that question pretty thoroughly in my comments. If you need any additional clarification, feel free to follow up in the chat. Otherwise, I think, Katie, you can run with the next question unless you have comments to add to this one.
The only thing I'd add is that if a board member is asking for any of these ballots before the election in their capacity as an individual owner, that is a different situation because they're not records of the association. It can't be requested by an owner until after the annual meeting. So if the board is asking for these as a whole board, that's different than one board member asking. I mean, now it sounds obvious as I'm saying it because it sounds kind of like election fraudy, but if it's about a board election. But just remember that board member in an individual capacity is different than the board as a whole. Okay, number 2. Just had a question come up in one of our associations about whether or not they should have to give notice about a board meeting to their residents. A special meeting was called for the sole purpose of the board to meet with the association's attorney to discuss the legal matter facing the association. Minutes were taken documenting the meeting as an executive session where no business was held. Should notice of this meeting be given to the owners, even though they would not have been able to observe any of the discussion? The short answer is under the HOA Act and WUCIOA, yes. They should have been given notice as required by the statute. The statute for the HOA Act is RCW 6438.035 subsection 4, which basically says you have to give notice of board meetings, and even if it's to consult with legal counsel, you can say that in the notice and just let everyone leave before, but you do have to give notice. If you are an old act or a new condo act with no open meeting requirement, either by statute, which doesn't exist by statute, and unless it's required by the governing documents, you don't have an open meeting requirement, you would not need to give notice. You would just do it as a normal board meeting. The notice has to be reasonable, like given the circumstances. So if it's an emergency meeting that you set up like 2 hours before your meeting with the attorney, it's probably not reasonable to send out a whole mailing to all the owners, but posting it on your website or sending an email blast that the meeting is happening may be considered reasonable. So even if no action is being taken and you have an open meeting requirement, you do need to give notice. The proper procedure would be to send out the notice, open the meeting, go into executive session and excuse all the non-board members, meet with the attorney, then go back into the open meeting to make any decisions. Any decisions cannot be taken in executive session. And then you reflect those decisions in the meeting minutes. Valerie, do you have anything to add?
I just want to emphasize the last thing that you just said, the very last section of your answer, which is that the proper procedure for conducting an executive session is that you are in your normal board meeting, and then somebody makes a motion to adjourn to executive session to discuss, XYZ, meet with the attorney, to review the attorney's memo on delinquencies, whatever the situation is. And then you adjourn to executive session, you discuss the matters at hand, you don't take any votes, with very, very few rare exceptions. You don't vote during executive session. Then you come back to your normal board meeting, and any actions that you want to take, any votes or motions or whatever that you need to occur during the board meeting, happen in your normal board meeting session. Whether it's open or not, whether you have an open meeting requirement or not, this is the correct procedure for executive session. And so your votes take place during the open session, and then your decisions get recorded in the minutes of the open meeting, or your normal board meeting session. A lot of communities think, well, the votes can't be recorded in the minutes because they're about confidential topics or whatever. And again, with very few exceptions, one of which might be decisions about like a competitive bidding process that you're in the middle of. With very, very few exceptions, you still take those votes and record those decisions in the minutes of your regular board meeting. So I just want to beat that drum and emphasize that part of the answer.
Yeah, and the decision that you vote on can be vague. So it could be vote to allow attorney to pursue claim. That's it. Doesn't say anything else about what the claim's about, who it's about, or anything. And
Right.
So then it's still keeping all the private information.
Exactly. Okay, I'm going to jump into our next question. Can you please go over the specifics of what is required to foreclose on a home in an HOA, please? I realize that the $2,000 in dues that needs to be owed, but is there a statute of limitations on past dues owed? Can you only charge so far back? Starting with your last question first, yes, there absolutely is a statute of limitations. So I'm going to start just by reminding everybody again, this is not legal advice. The exact circumstances for any particular account, for any specific client that you're dealing with might vary, and you want to consult with your association attorney if you have questions on what your options are with any particular account. That being said, the statute of limitations for HOAs is 6 years, and that is true whether you are an HOA Act community or whether you are a WUCIOA community. WUCIOA actually codifies the statute of limitations, meaning it's written right in the statute. The HOA Act actually is silent on the statute of limitations issue, but court cases have determined that the contract's statute of limitations applies for HOA Act communities, and that is 6 years. This is less of an issue for condo associations. Under the old Condo Act and the new Condo Act, the statute of limitations is 3 years. But this sort of competing thing of the statute of limitations with the threshold balance due, which I'll get into in a minute, is less of an issue for condo associations. So this answer, even though the process is true for all communities, some of the considerations are different for HOAs because of the typically lower amount of your assessments. So the steps to foreclose on a home, I want to start by saying you need to look at your governing documents to see if there's anything that is specifically required by your documents. So look to see if you have an alternative dispute resolution provision in your declaration, or even a section. There's different language in different documents. I've seen it called a condition precedent to action in some HOA Act, or some HOA declarations. And so you need to understand if your declaration in particular sets up any prerequisites to being able to file a lawsuit against an owner. This is not usually just about foreclosures. It's usually a section about dispute resolution or litigation in general. I would say 80% of the time, the declaration requirements that exist like this are written to exclude collection actions, which would include a foreclosure lawsuit. But a lot of times they don't treat collection actions differently. So this is something that you need to be aware of and that you should be consulting with your attorney on as you're making decisions about what your options are. As for the actual steps, again, assuming nothing in your documents requires a different procedure, the statutes now require that with the first written notice of a delinquency to your owner, first time their account falls behind, you're sending them the very first statement or delinquency notice that you mail to them. You have to now include with that first notice a statutory pre-foreclosure notice of delinquency. And it has to be sent to the owner both at the lot or the unit within the community, even if you know they don't live there, and to their offsite mailing address that they've given you if they have a different mailing address. And I, for some reason, the last week or so have been having a lot of conversations with different managers and board members who are really irritated by this new requirement. Because for a lot of valid reasons, right? Owners are going to panic if you give them a foreclosure notice with the first notice that says all they owe is $200, and they're going to call and yell at you and say, like, why are you sending me this? I only owe $200. You can't foreclose over $200, right? So I realize that there are a lot of valid reasons to be annoyed by the administrative burden and also the potential for backlash from your owners when you send this notice. However, the statute says you shall include a copy of this notice with the first written notice to the owner of their delinquency. And so the statute is mandatory. It makes this mandatory. And I don't want to, and I don't think most of my compatriots in our practice area want to, stand up in front of a judge and try to explain to a judge why my client didn't do it because they thought it was dumb. Not to put too fine a point on it, right? Or be too blunt about it, right? So this is a newly required step that just went into effect in July of 2023. The statutes, all of the common interest statutes include this requirement. So it doesn't matter what kind of community you are. If you don't know what the notice should look like, you can copy and paste most of it from the statute. But the statutes also require the association to periodically check the web links and the phone numbers that are on the notice to make sure that they're still valid. So if you don't want to be the one sort of bearing the burden of making sure that the notice complies with the statute, contact your association attorney. We draft them template letters or notices for our clients all the time. It should not be terribly cost prohibitive. And check with them maybe every 6 months or so to make sure the notice is still good, in that the links all work, the numbers are still all valid, because they do change every now and then. So the first step is include that statutory pre-foreclosure NOD, notice of delinquency, when you send out the first written notice of the owner's delinquency. The second notice of delinquency has to be mailed, cannot be mailed any sooner than 60 days after the first one. And it also cannot be mailed any sooner than 90 days after the delinquency arose. So at some point after the account is 90 days delinquent, and once it's been 60 days or more since you sent the first NOD, you have to send a second NOD. And again, I want to emphasize that the NODs have to be sent to the lot or unit address within the community, even if you know they don't live there, and to any other mailing address given to the association by the owner. The threshold balance due that has to exist before an association can file a foreclosure lawsuit is a minimum of $2,000 in unpaid assessments, or 3 months unpaid assessments, whichever is more, right? So for HOAs, we're always talking about the $2,000, because you don't have monthly assessments high enough to be more than 2,000, right? That either or thing is more of a calculation for condo associations with higher monthly dues. The statute requires that you calculate that threshold balance due by adding up all of the assessments, meaning monthly, quarterly, annual, whatever assessments, special assessments only, and then subtracting any payments you've received on the account from those assessments. In other words, you cannot include fines, management fees, attorney's fees, late fees, or interest charges in the calculation of that threshold balance due. And the owner has to owe, like I said, that minimum of $2,000 in assessments only, and 90 days has to have elapsed since that threshold balance due was met. And only once all those things are true can you then file a foreclosure lawsuit. So it might be evident from all of these details that this is a process you should be working very closely with your association attorney on, because we are the ones who are working with these statutory requirements day in and day out. And it's a lot to keep track of, I think, even for association attorneys as well. And so like internally in our office, whenever we file a foreclosure lawsuit, we actually do an internal risk assessment where every single attorney in our office is required to look at the file, look at the ledger, look at the notices, so that if one of us happens to make a mistake and miss one part of this process, one of the other 5 or 6 of us will catch it, right? So this is a process that it's complicated and annoying, but this is the process that's required. So I said earlier that I would talk a little bit about sort of like the competing considerations of the statute of limitations plus the threshold balance due. I think it's worth saying that for many HOAs, this new threshold balance due will make it impossible to ever file a foreclosure lawsuit, because the statute of limitations will make older amounts due uncollectible before you can ever reach that $2,000 mark, right? Let's say you are an HOA with annual assessments of $250, just for the purpose of round numbers. $250 for 5 years, your balance, assessment only balance due, assuming no payments have been made on the account, is $1,250, right? When you hit that 6-year mark, then it's $1,500. But then you hit the 7-year mark and it's still $1,500, because then the oldest year has to fall off because of the statute of limitations, right? So you're never going to get to that $2,000 mark if your annual assessments are this low and you've got that 6-year statute of limitations. I will also offer that some HOAs that I work with are already increasing their assessments as a result of this. They are looking down the pike. They're looking at their delinquency rate. They're looking at the rate of inflation, the cost of doing business. They're looking at the statute of limitations, and they're looking at this threshold balance due issue. And they are slowly starting to increase their assessments so they can position themselves to reach the $2,000 threshold before the statute of limitations eliminates their foreclosure option. So I'm not saying that that's necessarily, I'm not saying that as a suggestion for any community. I think only you as a board working with your manager can determine what rate of assessments is best for your community, but it's something that I have seen some communities do. All of that being said, I would like us to take a step back and remember that foreclosure is not the only option for collecting unpaid assessments. There are many other options, all of which are unaffected by this foreclosure process. You can record a lien. You can send a demand letter. Your attorney can send a demand letter. You can get the owner onto a payment plan. You can file a personal lawsuit against them, which would result in a judgment with which you can garnish bank accounts or wages. And you can also file a small claims lawsuit. If the balance due is relatively low, like we've been talking about, $1,500, $2,000, whatever, there is always the option for the board or your management company, if they do that, not all management companies do, to go to small claims court, file a claim, serve it on the owner, and go through the small claims process, which would eventually result in a personal judgment that you could then send to your attorney, who could collect on the judgment in the same way that we would sort of regular personal judgment that we obtain for you. So this is a daunting process. I do think the law of unintended consequences is in operation here. Some of you have been coming to the Q&A long enough to know that the threshold balance due used to be $200 or 3 months assessments, whichever was greater. And last legislative session, we did a lot of really close work with the legislature, including we helped draft some of the new legislation around the notices of delinquency. We negotiated for the option to be put into the statute that if an HOA was unaware of the NOD requirement, that the association attorney could send the NODs for you once an account came to us. In other words, that you're not out of luck if you just didn't know about that NOD requirement. Throughout that entire process, the threshold balance due was never mentioned. And at the very last minute, with no notice to the Legislative Action Committee, the sponsor of the bill changed the threshold balance due from that 200 to that 2,000. And I can tell you with almost certain, with a high degree of certainty, that nobody had walked them through what that would mean for most HOAs in Washington state in terms of hamstringing you guys and your ability to foreclose for unpaid assessments. So I don't want to talk too much longer on the subject. I think that I've covered it very thoroughly. If you have questions about the steps, you're welcome to put them in the chat or send them to us for a future Q&A. And Katie, did you have anything you wanted to add to this one?
Nope, I'm good.
Okay.
So the next one is under HOPA laws, which is housing of older people. If the declaration says that 80% of homes must be occupied by someone 55 or older, can the rules and regulations say that all rentals must be occupied by someone 55 or older? If the rules cannot say that, could this be added to the declaration, or would this be a problem because it's a stricter requirement for tenants than owners? So to start, as always, we have to say that this answer is for general information only, and it's not advice for your specific community. If you want that kind of advice, you should contact your association attorney. And now going to the actual question. And you can kind of see that when you read the questions, the person who's asking them is kind of answering them just as we would. So they're going through the right thought process. But starting in the end, we do believe that this is problematic and likely enforceable to have a different standard for tenants than owners.
Unenforceable, likely unenforceable. Sorry.
Unenforceable. Did I say enforceable?
You did.
Unenforceable. Likely unenforceable to have a different standard. If you did have this kind of restriction, it would need to be in your declaration, not your rules. If your community is governed by the Condo Act, it's likely a restriction on use, and this amendment would require at least 90% approval in order to pass. That's to amend the declaration. if you're an HOA Act or a WUCIOA community, there's a little bit more analysis required. An amendment like this would probably require a review of your governing documents to know whether the amendment could pass without a vote of every affected owner, like in Wilkerson versus Chihuahua, or if it could have been anticipated by the purchaser, in which case you would only need normal voting percentages to pass. But basically, the long story short is that this would need to be in your declaration, not your rules. Even if it was in your declaration, we think it's very problematic because you're treating people differently based on the status of ownership. But talk to your association attorney. Valerie, anything to add?
Nope, I think you covered it. Here is our next question. I am a board member and I was told by the new management company that I do not have access to invoices. Only 2 of 7 board members have access to invoices via the platform management uses. You have to log in. I was told I'm receiving financials, but I can't get access to invoices. Is this common? I don't think we can really comment on whether this is common or not. I think we have to confine our comments to a board member's ability to review invoices. So here's where we start on this. Invoices are a record of the association, and the board as a whole should have access to and be able to inspect, review invoices. In fact, often my understanding is that invoices would be like invoices that you're going to pay in the coming weeks would be included like in the packet of information that's provided to the board before the board meeting, right? So that the board has the opportunity to review invoices and then vote on whether they should be paid. Because invoices are a record of the association, I think it's also worth commenting that owners as a whole have the right to review those invoices, not just board members, right? That might be true after the invoices are paid, excuse me, whereas a board should have the ability to review invoices even before they're paid. If the question of this relates to timing, like the review of invoices prior to payment, then there could be some, like I said, variation in an owner's right to review, and we would need more specific information to be able to provide legal advice, which we don't do here, right, on who can review them and when. I also think that it's worth mentioning this could be governed by the management contract. So who has the authority to access specific parts of the management portal or information platform, whatever that looks like, could be governed by specific terms within the management contract. And the management contract may also provide for a limited number of access points to the association in real time. The management contract might also provide that the board has to appoint a board member to be the manager's liaison with the board, right? So there's a lot of different moving parts here in terms of the timing of the invoice review. What does the management contract say about this? But in general, and without knowing all of those other specifics, we think it's likely problematic if you have a manager that's refusing to allow the board as a whole to review invoices. And you might notice that I keep saying the board as a whole, the board as a whole, the board as a whole, right? If you are, as an individual person, reaching out to the manager and trying to review copies of the invoices because you just want to, that is one thing. If you, as a 7-member board, are asking the manager to disclose copies of the invoices to the full board and the manager is refusing, that's a different thing, right? And so that's a whole lot of general information, but in order to get advice on your specific scenario and whether you have grounds to ask your manager to modify their practice with respect to invoices, you need to consult with your association attorney, and that also is a decision for the board as a whole. Katie, did you want to add anything to that?
Not specifically, but there is a follow-up question, which is, can owners view estimates or invoices? And I think you covered invoices. They can be reviewed after. Estimates, I think, are a little bit more complicated because you can withhold contracts and bids that are currently being negotiated. So if those estimates are part of that process, that's different than the estimates you receive after the fact and after you've selected your contractor.
Yeah, the timing is everything on the estimate question. So if you're currently in the negotiation process, I think those can be kept confidential from the ownership. But once the contract has been signed and you've got estimates from 6 months ago before you selected your contractor and an owner asks to review all the estimates, I think that is a record of the association. The owner has a right to review.
All right, and with that, the next question is the budget ratification meeting a homeowner meeting? If yes, are proxy statements required to be sent out to all owners with the budget meeting notice? So first, we answered this question on the January 10th Q&A, but the short answer is the budget ratification is a homeowner meeting. You are required to accept proxies, but you are not required to prepare the proxy forms. This is true for all homeowner meetings. You don't need to include a statement that an owner can submit a proxy with the ballot that you send out, but you can. So basically, I think you're asking if you have to tell owners they can send a proxy. The answer is no, you don't have to tell them. But if they send a proxy and it complies with all the proxy requirements that we've talked about, then you have to accept it. It's also worth noting that the budget is ratified unless it's rejected. So if no one shows up at the meeting and there are no proxies, then it's considered ratified. Anything to add?
Nothing to add, you covered it. All right, here is our next question. A property management company only asks the board president for approval of non-emergency repairs or replacements for limited or common elements that have not been previously discussed or approved at board meetings. Is this okay? So this also depends on a lot of different factors. And so we cannot answer this question for your community without giving legal advice, which we don't do here. But it depends on a number of things. Has authority been delegated by the board to make decisions, financial decisions of up to a certain dollar amount? If the board as a whole votes to give the board president authority for decisions up to a certain amount, then this could be okay for a non-WUCIOA community. I want to point out that WUCIOA requires that all but ministerial decisions be made at an open board meeting. And so because we've got this WUCIOA for All bill coming down the pike, this is also a procedure that most other communities are likely to be subject to in the future. And so maybe y'all should start practicing because you're all going to be subject to these WUCIOA requirements like open board meetings and limiting the types of decisions that can be made outside of board meetings. The answer to this question might also depend on the management contract. Many state, like I said before, that there should be a single point of contact for the manager. And if that contact is the president, then it might be appropriate for the manager to only ask the president. And it would be then incumbent on the president to confer with the board or add this to the board meeting agenda for the next, board meeting, etc. In general, our expectation would be non-emergency items should be discussed at the next board meeting. Emergency items could be handled in real time as necessary. But I also think we've talked many times before on this Q&A about the definition of emergency. And I would say the vast majority of board decisions are non-emergency items. And so keep that in mind when handling things like this. So I can't tell you whether the way your particular community is handling it is okay. And unless you're on the board, you're saying they haven't been previously discussed or approved at board meetings, but you might not realize, for example, what the management contract says, or whether there's been a board vote in the past about giving your board president authority up to a certain point. So these are just some general considerations and not specific to your circumstances. Katie, did you have anything you wanted to add to that?
Nope.
Okay.
So the next question is, we borrowed funds from the reserve accounts. RCW 6434-384 states that we adopt a repayment schedule not to exceed 24 months unless the board determines that repayment within 24 months would impose an unreasonable burden on the unit owners. Does this mean we can extend the repayment schedule more than 24 months and or not have to repay the borrowed amount at all if it will create an undue burden? Yes. Yes, if the board determines based on a lot of considerations that it's an undue burden to repay under 24 months or to repay it at all, you don't have to replenish your reserves. It's not something we typically recommend. There are several considerations, some of them being what projects do you have on the horizon? How many owners do you have to spread the cost of replenishing? What is it for? It may be that the expense you're thinking about is already a considered reserve expense, so this statute wouldn't apply anyway. This only applies when you are taking reserve funds for non-reserve expenses. That being said, the language of the statute hasn't been clarified by the courts, so it could be up for interpretation. So it could be either a repayment in 24 months and more times required, or no repayment at all. So the board just has to make that decision based on all available information and meet its duty of care. You could also allow the reserve study to project what repayment is necessary when you update it. Valerie, do you have anything to add to that?
Yeah, I mean, I think just like anything else, your board's decision on this question has to be reasonable, right? You got to comply with the statute and you have to be reasonable. And there are a lot of variables that would make repayment or not either reasonable or not reasonable, depending on the circumstances. So for example, if you have a roof replacement happening next year and you borrowed, I don't know, $50,000 from your reserve account for legal expenses, like just pulling some details out of my hat here, it might be unreasonable not to replenish because otherwise you're looking at a significant special assessment in order to pay the cost of that roof replacement in 2 years or whatever, right? Whereas if you're already 80% funded and you have no large expenses coming up in the next couple of years, and the burden of repayment within 2 years doesn't come with a significant risk in terms of your future costs, it might be reasonable to choose not to repay. I think the important thing is that the board has to be aware of this requirement in the statute. They have to discuss it and they have to make a decision. And I also think you need to communicate that decision with it to your ownership, because the statute also does require disclosure to the owners when you borrow from the reserves. And so if you then decide later not to repay it, you should follow up with a disclosure of that decision to the ownership as well. Okay, next question. Our garage has assigned parking spaces, which the owner receives when they buy a condo, as well as common area. We have an owner's son who has started using the common area for his own personal use. He brought in exercise equipment without approval, but then the board approved it after the fact. He's now started parking a motorcycle in the common area. Do you have any suggestions on how to legally handle this? So I feel like a broken record, but I'm going to again start by saying that this is too specific for us to answer for your particular community and circumstances. We haven't reviewed your governing documents. We haven't looked at your rules, and we would need to do all of that before advising a client on this. So if you want legal suggestions for your specific situation, you need to contact your association attorney and pay for them to give you legal advice on this question. Generally, I will say that boards have the authority to restrict and govern the way common areas are used. And if your rules are properly adopted by the board and then communicated to the ownership, those are enforceable, even if the person breaking the rule is a guest, a tenant, family member, or other person invited into the community by the owner. But your enforcement relationship is with the owner. So remember that, right? Like you're not finding the owner's son, you're not finding the owner's girlfriend, you're not finding the owner's overnight guest from Texas or whatever, right? When one of the owner's invitees breaks your rules and you follow your enforcement process under your governing documents, you can fine the owner. Again, follow all the right processes. You have to give due process. You have to have a fine schedule that's published to your ownership in advance, etc. But you can take enforcement action against the owner for the behavior of their guests. If part of the question is, can you remove an owner's personal property from the common elements? And if the stuff has only been there for a relatively short period of time, the answer might be yes, but that is, again, specific enough that I would want you to consult with your association attorney. There have been times when an owner has used a common area long enough that it's created, I think we call it an equitable servitude situation, where it's a little bit more complicated than like get your stuff off the common areas or we're going to put it in the dumpster kind of situation. So that's why I'm saying you have to be consulting with your association attorney, in particular if you're looking for ways to reclaim the common areas that are currently being used by that individual. Katie, did you have anything to add to that one?
No. So
Okay.
I'll just jump into the last one of our pre-submitted questions, and I know we have some in the chat that we will probably have time to get to. I'd love to go over the new Corporate Transparency Act industry standards, if there are any. For example, attorneys versus management companies handling these filings, how that works for declarants, etc. So to start, we did cover this in last week's Q&A, and so we recommend you go over there on the YouTube channel to watch it. This is currently a massive topic of discussion within CAI on the message boards. It's probably too soon for industry standards. I did some Googling and there are several blog posts, but none of them neatly lay out any industry standards. We are attending a seminar next week to learn more, and here's the link. It's put on by CAI, and I accidentally just sent it to only Chelsea. There we go. If you want to learn more, get more details, there is a fee, but that might answer a lot more questions. Like I said, I'm attending it, so hopefully after that we should be able to answer a lot more questions. That being said, in terms of who handles the filings and how it works for declarants, the declarant would almost certainly be considered a beneficial owner, especially while they're in control. So they would need to submit the form and list their name. When they're no longer in control, the association likely just submits a new form with the current board members. But again, this statute wasn't written with associations as the focus. So there are a lot of things that have raised questions, which again, that seminar will probably answer. As for who files it, the management company can file the form just the same as other forms are submitted on behalf of the association. You could have it submitted by an attorney, but it may not be worth the costs. It's just like any other tax form that can be submitted. So I know that's not probably as much information as you were hoping for, but this is a relatively new thing and we are also still working out the kinks.
I'm going to jump in and say that we did, like Katie said, cover this topic a little bit more in detail last week. So if you would like to see what we said last week, just scroll up to the top of the meeting chat and snag the link for the YouTube channel and look at the video for January 17th of this year. I also want to say that, as Katie mentioned, the target of this legislation was not community associations. This is, again, something I mentioned earlier with respect to the foreclosure thing. Sometimes there's unintended consequences of legislation, right? The legislators are only human and they can't envision or, imagine all of the possible ramifications of legislation when it's being proposed or enacted. And so I think this is very clearly a scenario of unintended consequences. That being said, I also do think that until it is modified to exempt community associations, your safest and lowest risk course of action is to file the paperwork that's required by the Act. So I would encourage anybody who is, in particular, I think managers, but also self-managed board members, to try to attend the webinar that CAI National is putting on. I do know that there's some effort at the national level to get an amendment passed at some point to exempt HOAs, but I'm not sure how quickly that's going to happen. So jumping into the questions that have come in to the chat. The first one that I see, and Katie, jump in if you think I'm missing anything. If the legislature forces us to move to WUCIOA, will they also provide funding to get our declarations and bylaws updated? I'm going to say tongue in cheek that you guys know the answer to that question. But that being said, I think right now, one of the things I'm hearing a lot of panic about, and this even happened at the committee where people were testifying either in support of or against the WUCIOA bill, is this perception that all of a sudden, when this happens, you're going to have to completely amend your governing documents. And that is almost certainly not the case. If this particular bill becomes law, I think there are a couple of things worth noting. Number one, it will not take effect until January 1st of 2026. So you'll have a year and a half a little bit more than that. Actually, I mean, from now, that's 2 years, right? So you'll have a couple years to make any modifications that you might like to make to your governing documents before this statute takes effect. The other thing that's worth mentioning is that statute is going to trump what your governing documents say, even if you don't modify your governing documents. So you will not be required to amend your governing documents. It's easy to say that. And the reality is, of course, that when your documents say one thing and state law says another thing, it does create a lot of confusion. You may get a lot of owners saying, but you were supposed to X, Y, Z, because that's what your documents say, even if the statute has overridden your documents. So as a practical matter, yes, long-term, many communities, in particular where there are significant conflicts, may want to or choose to update their governing documents, but you are not going to lose the ability to enforce consistent provisions of your governing documents just because you don't amend them before the statute takes effect. And the statute will take effect and will override your governing documents even if you don't change the documents. Katie, did you have anything you wanted to add to that?
The only thing I'll add is that that's already, for non-WUCIOA, that's already the case when the statutes are updated. So the foreclosure statute that was updated, the voting requirements, the record statute that was updated in July, all of those already trump whatever's in your documents.
Yep.
And so this would just be a bigger, more impactful extension of that.
Yeah, that's a great point. All right, the next question that we had in the chat is, what is the process for a board that wants to access phone numbers and email addresses of their owners? Katie, do you want to run with that one?
Well, I'll start with the email. If the owner hasn't given you their email or opted in, then I don't think you can access it. Same with their non-phone book phone number, if that makes sense.
Unlisted.
Listed, yeah. So I guess it also depends on what purpose you are trying to do it for. Valerie,
Yeah.
maybe you should. I
Yeah,
feel like
I
you just access it if you need to like send them a notice.
Well, here's the thing. Your roster of owners, including their, I'm pulling up a statute while I'm talking, so forgive me if I'm a little bit slow here. Including your list of owners, including their names and phone numbers and email addresses, is a record of the association, right? And board members are the group that govern the association. And so with very few exceptions, the board as a whole, again, there's that phrase, as a whole, has the right to access the list of ownership contact information, assuming they're doing so for a proper purpose, right? So I think that's where we start, is that the list of owners, including their contact information, is a record of the association. I do think that it's worth noting that the recent changes to or additions to our statutes with respect to records contain some very specific information about the list of your owners. So one of the things that an association is required to keep is a list of unit owners that must be made available for examination and copying by the ownership. That list does not include unlisted telephone numbers or email addresses unless owners specifically allow that information to be disclosed. So owners are entitled to an electronic copy of the list of unit owners at least once a year for free. They can ask for it more frequently. You still have to allow them to review it if it's more than once per year, but you may be able to charge them a reasonable cost if that is the case. But again, that list does not include email addresses and unlisted phone numbers. It's names, unit numbers, and addresses. That's what that list is for. But I guess I would need more information before I answered this question beyond that, because if the board wants the manager to produce an owner roster list, including phone numbers and email addresses, so the board can, I don't know, reach out to the ownership directly and like schedule a community meeting or find out if people want to opt into electronic notices or whatever, those are all proper purposes of the board acting in its governance capacity. If the board or a board member asks for the list because they want to start, you know, emailing people to influence the outcome of an election or whatever, the answer might be different. And so I think that's all we can say from a general point of view without knowing more and without venturing across the line into legal advice.
One other thing is there is an exception for owners requesting the roster for people who have protected addresses and protected
Yes.
information under, I think, a few specific statutes. So one is the Domestic Violence or Violence Against Women Act. So
Yes.
before you just send everyone, just double check that
Yep.
an exception doesn't apply.
That's a great point. Okay, we have another question here. We have a finance committee and a budget committee. We are a 225 unit HOA and the board manages our golf course and clubhouse. We have provided notice of these meetings to owners, but we have these meetings closed due to materials being reviewed and discussed. Are we allowed to do this? We are governed under 6438. We do not make any motions during these meetings, just provide recommendations to the board. So, board meetings have to be open. Committee meetings don't, I think that you should run your committee meetings the way you run your board meetings. That's my advice. I will say this for two reasons. Number one, sometimes committees are empowered to make decisions on behalf of the board. If there's two or more board members participating in the committee and any type of decision is being made, then it should absolutely be treated like a board meeting, even though it isn't technically a board meeting. The other reason is that WUCIOA does require committee meetings like this to be open, just like board meetings are. And again, with the WUCIOA for All bill coming down the pike, even if this is not technically required for your community now, it's going to be or likely to be in the near future. I also want to remind folks what we've said before, the making motions or decisions, that is not the dispositive question when it comes to whether your meetings have to be open. If your meetings have to be open, it doesn't matter whether you make motions or decisions or not, they have to be open. And if you have confidential stuff that is sort of confidential enough that it is exempt from disclosure to your ownership, then you can adjourn into an executive session to discuss just that private information and then come back to your open session to conclude the meeting so that you're following proper procedure. Katie, did you have anything you wanted to add on that one?
Yeah, I think for the associations that are under the statutes that have open meeting requirements, the legislature is pretty clear about the intent that owners are informed and things are available to the public or to the ownership. Having committee meetings to inform the board of stuff that would otherwise be discussed at an open board meeting seems contrary to the legislative intent and could be seen as a way of just skirting around opening things up to the owners so that they're informed. So, because otherwise you could just have a bunch of committees and then owners wouldn't know anything. So I think it's contrary to the open meeting requirements in the statutes.
Thanks, Katie. Okay, I think we're not going to get to all the questions from the chat, but we do have one more that I think is quick enough for us to get to, which is a follow-up to the statutory foreclosure notice question. And the person just asked for the RCW citation. And I'm going to give it to you for every single one of the governing statutes. But just as a cheat in the future, if you just look up RCW and your particular chapter, 6438 if you're an HOA, and then you put in delinquency, then it will take you, the search result will take you to the section that you need to look at. But for HOA Act communities, it's RCW 6438-100. For Old Act communities, it's 6432-200. For New Condo Act communities, it's 6434-364. And for WUCIOA communities, it's 6490-485. So those are all of the common interest statute sections that deal with the pre-foreclosure notice of delinquency. And I think that is all we're going to be able to get to today. Thank you very much for joining us. We will go ahead and put the couple of questions that are left over from today into the list for next week, and we will see you guys then. Bye, everybody.